Welcome to all. Welcome to Sriram IAS Academy in this Unacademy platform. My name is Lala Ignatius. Here I am going to take the polity part, and this is our rapid revision class. So you know very well the way how the process regarding the rapid revision class we are planning. So it will help student to manage their preliminary part at the time of 2023 examination. So there was a purpose we are planning to go for an idea like a rapid revision. So the people those who are very serious for 2023 can able to join with this, and for the continuous 5 classes, the way how I'm going to discuss about the various important features of Indian polity. Based on that, both can able to have some kind of knowledge, and you can also get some kind of benefit at the time of your examination. Fine, good. So now this is a case when I want to look into the matters regarding Indian polity. We know very well the way how the process regarding polity. So when I'm looking into sorry, when I'm looking into the ideas of polity, so the most important thing, the way how the process regarding polities are happening. One second, I'll take the pen. Okay, the process regarding polity. We know very well the way how at the time of 26th November 1949 and 26th January 1950. These are all the two important days we can able to keep it in order to recollect the ideas of the enactment of Indian Constitution and the commencement of Indian Constitution. 26th November 1949, the enactment of Indian Constitution, and 26th January 1950, the commencement of Indian Constitution. Okay, so when you are going to look into this matter, but the possibilities are there in what way UPSC can able to ask some question and how the way UPSC already asked some question. So when I'm going to look into the process of constitution, we know very well the constitution we are having at present, okay, is on with the help of, there is a body in the name of assembly, in the name of constitutional assembly. I can able to say constitutional assembly. Okay, and this constitutional assembly is the most important body because when a country want to go for the enactment of the constitution, definitely that country need an assembly. This was an idea initiated by Mr. M.N. Roy around 1934. The Roy, M.N. Roy, around 1934, he was a prominent personality. Okay, and inside the Indian historical scenario, who first initiated the process regarding constitutional assembly. And after Mr. M.N. Roy, he also a popular communist international leader. The way how the Constitutional Assembly related ideas initiated by Mr. M.N. Roy, later followed by various political leaders and various missions like Cripps and Cabinet. And finally, it was at the time of 9th December 1946. These are all the fact-oriented things for your public service examination. 9th December 1946. The enactment of the Constitutional Assembly, the beginning of the Constitutional Assembly came into existence. And when Constitutional Assembly for the purpose of the creation of Constitution came into existence, then definitely there will be a guidelines. M.N. Roy, who initiated the process of assembly, on the basis of that, at last, finally, it was in 9th December 1946, the British Parliament accepted the process regarding Constitutional Assembly, and within few days, on 13th December 1946, Jawaharlal Nehru, who created the most important concept in the name of objective resolution, OR people will say. The objective resolution was initiated by Mr. Nehru. On the basis of that, the way how our constitutional makers, with the help of various committees, starting from the drafting committee to other various steering committee, they had decided to go for the methods of the Constitutional Assembly and other related process. And this process was initiated on 9th December 1946 and continued their process in so many days. Approximately, I can able to say that the entire Constitutional Assembly, the way how it is debated and discussed about the various nature, finally, the Constitutional Assembly enacted the Indian Constitution on 26th November 1949. On the basis of that, the necessary point and most important thing we can able to say that the way how the Constitutional Assembly enactment on one side. But it almost took 2 years, 11 months, and 18 days in order to commence this process, and the enactment came into exist. And after that, 26th of January 1950, remaining all came into exist. This is the normal scenario or common concept we can able to say. But the entire process regarding constitutional making ended at the time of 26th January 1950, but the process related to the Constitutional Assembly came into exist by the way. First, a kind of idea we can able to say, the Battle of Buxar 1964, the combined army of Shah Alam II and Nawab of Oudh and Bengal in the name of Mir Kazim and all, etc., etc., Sudaudaula, all these people combinedly and tried to defeat the British army, but the result came in favor of British. And after that, in 1965, the Treaty of Allahabad followed into the matter of Battle of Buxar. Based on that, the enactment of the new process in the name of dual form of government, a diarchy kind of things that came into exist. So this is the way, this is the beginning. From the time of 1765 to 1773, the way how during the time of 1765 to 1773, the East India Company, a company which want to govern the affairs of the government of India, Bengal, or their own employees, on the basis of that, finally, the British Parliament decided a person like Robert Clive, who came from England as an ordinary non-covenant civil servant in the name of clerical level officer, who returned back to the United Kingdom in the name of the retired governor of Bengal, and he had a huge amount. On the basis of that, the social isolation also came into exist, because everybody doubted that he did corruption inside Bengal. Based on that principle, he also committed suicide on one side. That's a negative aspect of Robert Clive. Okay, but the government started thinking that okay, it is the time the government, British Parliament, need to do some kind of activity. Based on that, at last, 1773, the Regulating Act came into exist, and the key important principle we can able to say, as part of the Regulating Act, the Governor of Bengal promoted as a Governor General of Bengal. And on the basis of the 1773 Regulating Act, gave some confirmation to the previous year initiative of establishment of Supreme Court. And apart from this, this act only laid a foundation on the basis of the way how the East India Company affairs is going to be governed by the government, as a kind of process also started from the beginning of 1773 Regulating Act. So this process came into, this a kind of initiation came into. And next important thing, after this idea of Pitt's India Act, Regulating Act 1773, Regulating Act 1773, there are some more provisions like what we can able to say, the Pitt's India Act. It was otherwise called as Young Pitt, the youngest prime minister during the time of 1780s, and who decided to regulate the affairs of East India Company in various ways. So he decided to go for the creation of Board of Control in UK. Okay, and there is a second important thing, the East India Company, who had some kind of monopoly in terms of trade, only into the category of trade, as exclusively given to East India Company. Because when I'm looking into the matter of East India Company, it got the right from the Queen around 1600 on the basis of the charter the Queen gave to East India Company. Until 1857, East India Company as a multinational company or the transnational company who governed the administration on the eastern part of United Kingdom. Okay, and after revolt of 1857 only, the authority from East India Company has taken completely. British Parliament took the direct authority on the basis of the creation of a Secretary of State and all. That all we are going to discuss. But the monopoly of the trade for the companies as exclusively given on the basis of Pitt's India Act. And the formation of dual government between British and East India Company. In Battle of Buxar, the government representative from East India Company and a king or Nawab representative, there was a diarchy that time. But in 1784, the British government on one side and East India Company on another side, that dual form of government came into exist. And other than that, when you are going to look into this idea, the Governor General of Bengal later made as a real ruler of the entire British Parliament, entire British territory which exists inside the place. So this is a way some kind of initiation happened. But even before that, there was an idea in the name of 1781, simple, some preliminary perspective, there may be a possibility that this act restricted the application of English law to only Englishmen in order to avoid any kind of local conflict. But this concept was somewhat managed on the basis of the Bengal Regulation Act 1793. On the basis of the Bengal Regulation Act, the government, the Supreme Court gave some kind of right to take decision on the person and property of India. Every court inside the country of British India, through the Bengal Regulation Act, got the right to handle the matters regarding Indian people and their property, which came into existence. And later part, when you are moving further, so the concept regarding 1813 Regulating Act become another important thing. This only was asked by UPSC 2 years ago, and after this question came, now every guides also inserted this provision. Before the old edition, we won't find this topic, but now every books are having this, every guides are having this information. But as per the original source of National Book Trust only, I am discussing this class. Okay, NCERT and NBT, I am continuing this class. So as per the NBT and NCERT, 1813 Council of India Act or the Charter Act are very important because it ended the monopoly. Because previously I told the monopoly of trade with the British East India Company exclusively. But 1813 Act completely ended the monopoly of trade, okay, of East India Company with India. But trade with China and China remains exclusive to East India Company. That was a highlighting point. And immediately after 20, every 20 years one, you can able to see the charters. The 1833 Charter Act gave some kind of provision. On the basis of that, the Governor General of Bengal became a Governor General of India. The first important thing. So the territory of India, as per the NCERT of 12th standard, 1818, I can able to say, almost except Punjab and Sindhu was under the control of East India Company. And after that 1833 Act, even including Punjab and Sindhu also included as a part of the government of India, British India, on the basis. So once the territory became wider, the Governor General of Bengal became the great Governor General of the whole India, and that was the initiation regarding centralization process. Based on that, I can able to say some more provision in the name of the commercial body, the category they have given to East India Company, and this Act 1833 finished the chapter of commercial body to the nature of East India Company. But the other important provision I can able to say that the employment opportunity the East India Company is going to. So Indians are not debarred. So Indians can also permitted to this nature to have employment opportunity inside East India Company. Before that, no Indian to be debarred. Now Indian to be debarred in this condition. And the way how the centralization process in various way came into exist, and even the provisions regarding capital of Calcutta, okay, was so the presidency were reporting the governor general like that. Some other important thing, the law commission under Lord Macaulay. It was a initiation at the time of 1933 came into exist. That idea we know very well. Already you might be studied in your foundation classes that law commission came into exist in 1833, worked continuously. At last, finally in 1859, they got the Indian Penal Code IPC came into exist, and it also got the approval with 1861 Council of India Act. Then when I'm moving further the next level, the Charter Act of 1853. So a question may come very specific, like the Charter Act of 1833 was last year preliminary question. For every now and then, some kind of act will be appear. So when I'm going to look into this 1853 Act, so this act first time initiated the process regarding separation of legislative and executive function of the Governor General's Council. So it should be separately, not by one body. Executive, that is different. Legislature, that is different. Even directive principles, we can able to see this kind of idea. And other than that, when people from UK, United Kingdom of Europe, refused to come to India, a country which popular for famine and disease and all, So British government decided to go for inducting Indians inside civil services. So first time this act also introduced a concept of open competition in civil service. When I'm going to look into this open competition, even it is not United Kingdom, not America, India, British India was the first place where the concept regarding open competition came into exist. So when I'm looking into the open competition in India, British India, even though the Act gave this provision of 1853, Act gave the provision of open competition, but was not introduced inside until the direct control of British Parliament took the charge through 1858 Act. One side. And second important side, after inducting this process, later in United Kingdom also, they inducted the process of civil services through open competition. But until 1883, this process was not inducted into the world most powerful democracy in the name of United States of America, USA. But after 1883, the American system completely stopped the methods of spoils, we can able to say. The spoil system was practiced by Americans inside America until 1883. After assassination of General Garfield, the President of America, then the spoil system got completely removed. Spoil means party-based system. There was an idea, and open competition also came into existence since 1883. But when I'm reversing the process, till now, 75% of the American people, civil services through open competition, and 25% on the basis of the spoils, political appointment. Now in India, since 1853 or since 1858, the open competition, always inside civil services. But after 2019, the process regarding lateral entry also permitted inside Indian civil services. But the entire process came into existence with the help of the 1853 Charter Act. After 1853, I have to remodify my word and act in the name of Government of India Act. Because the previous act before 1858 only discussed in the name of Charter Act or Regulating Act, which really want to regulate the affairs of East India Company. But when revolt happened in 1857, there was a first initiative directly took the control of Parliament of India. So based on that, so Government of India Act, it is not regulating the affairs of company or other things. So Charter and regulating moved into the different category of Council of India Act or Government of India Act. So based on these principles of 1858, sometimes UPSC may ask some kind of question directly in this line. When I want to look into this process, the most important thing that 1857 revolt came into existence, even just before COVID virus, the Ministry of Human Resource Development initiated something that 1818 Paikal Rebellion is a thing considered as a first war of independence. 1818 Paikal Rebellion. But even the government asked the HRD ministry to do the modification in syllabus that it is not considered that Government of India, the 1857 revolt as a first war of independence should be moved into 1818 Paikal Rebellion as a first war of independence. So based on this conflict, there may be a possibility UPSC may ask some kind of question in this year, 23, that generally people will say 1857 revolt as a first war of independence. Majority of the Indians, even the person like V.D. Savarkar wrote a book regarding this particular area. But majority of the Western scholars accepted this 1857 as an outbreak, sudden outbreak. It's a mutiny of the landholders who lost the territory, Jamindars who lost their territory, like that manner. There was only one scholar from the Western side who accepted 1857 revolt as a first war of independence and also wrote a book related to this idea. His name was Karl Marx. Karl Marx, in the sense that we know only Das Kapital or other various process in the name of the Communist Manifesto, etc., etc. The same, Karl Marx wrote a book about India's 1857 revolt as a first war of independence, and there is a popular book even available today. So this is the way the things we can able to say that. I think already I mentioned here in this point that first war of independence, Karl Marx, the book was. Okay, so 1858 Act, British took the direct control, and Crown took the direct initiative, and a new position in the name of the senior most member of British cabinet, who became the Secretary General of India, and for assisting him, there will be a person in the name of Governor General as an agent to the crown. So agent will be considered as a viceroy. Okay, and the viceroy can able to do certain activities with the concurrent jurisdiction of Secretary General of State. So this is the way the coexistence of Secretary of General, a senior most British cabinet, and a viceroy, the representative of the crown inside India as a Governor General, continued inside in our country. But in later part, there is a modification what we did it in 1853. The open competition is a kind of idea initiated by Charter Act of 1853, but it was rejected by the Board of Control. But after 1858 revolt, that the act came that the British decided to go for civil services through open competition. There was an idea slowly and steadily enter into the Indian territory. Then apart from this, there is another most important source I can able to say. When I want to look into the making of Indian Constitution, at that time I will say that 75% of the Indian Constitution we borrowed it from Government of India Act 1935. 25% we borrowed it from various sources like UK, USA, France, Japan, Soviet Russia, or something in the name of South Africa or Ireland, something like that I will say. But even some provision you should be very, very careful. Some other provisions we not borrowed from Government of India Act. The initiation happened at the time of Government of India Act 1861. The best example I can able to say that the portfolio allocation. It is a prerogative power of the Prime Minister of India at present. Allocating portfolio to various ministers is a kind of idea. First time appeared in 1859 and 1860s and 1861 with the approval of Government of India Act 1861. And the second important thing, the portfolio allocation at the time of 1850. And first time the concept like budget was introduced by Canning during the time of 1860. Okay, and other than that, there are some provision in the name of ordinance making power of president. Right now, we can say under Article 123 of the Indian Constitution or 213 of the governor, and veto making power of the president, like absolute, discretionary, or the subjective or quantitative, and other various vetoes the Prime Minister, President of India is having. All those ideas got it its own significance and origin with the help of Government of India Act 1861. And apart from that, some more initiatives in the regarding the prior sanction of the viceroy is necessary to introduce certain initiatives. The same way I can able to say the prior sanction of the president, prior recommendation of the president is necessary for introducing certain bills, including a simple ordinary bill in the name of constitutional state reorganization bill under Article 4 and 3 and 2. The initiation is going to happen. All those things will come under the category of the prior sanction of the viceroy is a kind of idea also got it from 1861 Council of India Act. And apart from this, the legislature, the way how it is passing an act, all need to be get the subject approval of the Assembly and Majesty on the basis of the approval of Secretary General. And the way how the Viceroy, Governor General using the ideas of veto power and ordinance making power in terms of emergency, a proper channelization, and the portfolio I already discussed. And the most important thing, this act only initiated the process of decentralization and representative institution inside the country. UPSC may ask very specifically these kind of points. Okay, then you should be very, very alert because single point they will ask the process of decentralization, a representative institution in India based on the following act, like this man. Then some more ideas. The most important thing, the Council of India Act 1892, which brought the principles first time inside the country in the name of election in direct manner. Okay, and apart from this, this act even long back 1860s, the budget as a process came into existence. And right now in India, on the basis of Article 112 of the Indian Constitution, we are using the idea of annual financial statement or financial statement. You might be studying your polity foundational classes, but not in the term of budget. Budget you won't find anywhere inside our Indian Constitution. Everywhere you are going to find annual financial statement only. So the power to make some kind of discussion regarding budget first time came to exist with the help of Indian Council Act 1892. And other than that, when I'm moving further, the 1909 Indian Council Act. So when I want to discuss about the 1909 Indian Council Act, the most important thing is that a new kind of initiative to suppress the Hindu-Muslim unity in the name of separate electorate. Because we know very well, in 1905, the partition of Bengal kind of initiative and immediately followed by anti-partition of Bengal. And the anti-partition of Bengal movement is so real reality that how the way the Indians are united together, by the way, how the Hindus allowed to preach inside the Muslims pulpit and Muslims are given key to maintain Hindu temples, highest level of Hindu-Muslim unity. So based on that, to divide this idea of divide and rule or characteristic policy, the Council of India Act 1908 introduced the idea of separate electorate for Muslims. And previously they asked some power with the help of discussion about the budget, now updated into the category of power not only discuss but also asking some question in the matters of public importance, slowly inducted into 1909. And 1919 in Council of India Act, Montagu-Chelmsford Council of India Act is another important thing because it got some kind of preamble kind of things. In the preamble, it discuss about Indian government is going to have a methods of decentralized unitary form of government. Decentralized unitary form of government. This is an initiative. Later part, we accepted the idea of federal principle, not from United States of America, but from Canada. We got the idea of federal principle with a strong unitary bias. It's a kind of methods. Even before the utilization of this Canadian methods, we practice inside our country on the basis of the preamble 1919, which gave the concept to Indian people under the name of decentralized unitary form of government. And other most important thing, the decentralization process started through 1918. So there should be a kind of ideology that the entire process of the governance is going to divide into two categories. One is transferred list and another one is reserved subjects. So transferred list where they can able to handle the normal matter regarding sanitation, water, PWD and all with managed by Indian people, because very soon they plan to go for election. First direct election through Government of India Act 1919. So they separated the property that Indian minister through Indian election, direct election will handle those areas and Governor General will handle, governors will handle the important functions of military, law and order, state, foreign affairs and etc. So like this manner, the process of Government of India Act 1919 came into exist along with some more principles that the diarchy was introduced inside the province on the basis of that one side governor, another side people elected provincial head, something like that. And the governor and chief minister, way how right now the same diarchy was initiated at the province and direct election happened in 1929 to 21, first time in Indian history, direct election on the basis of Government of India Act 1990. And communal electorate not only for Muslim in 1909, but in 1919, the people like Sikh, Christians, Anglo-Indian, European, all got separate communal electorate. Okay, but while doing so, the 21 direct election on the basis of Government of India Act 1919 gave some kind of meaning to the act that on the basis of that, the British government kept some kind of conditions. Because once India got independence, we announced Universal Adult Franchise, UAF. It was the initiative even happened such a long time through Nehru Committee recommendation or Sardar Vallabhbhai Patel's initiative through Karachi session and all. But when first direct election came into existence in India, British India, they kept some condition that votings can be given to people not on the basis of Article 326 Universal Adult Franchise. There are some conditions in the name of land holding. How many acres land you are having in your hand? What about the tax you are paying to British government? And what about your literacy rate, literature? So tax, literature, and land holding. These are the three conditions. Based on that, only people can able to go into the nature of voting right. So the moment India got independence, independent India go for independent first election in 1951 and all, and India decided to go for universal adult franchise under the Article 326 of the Indian Constitution on the basis of the right to vote and right to be a representative, become part of the people of India as a foundational right, not a foundational right. For implementing this constitutional right 326, there was a necessary for the parliament to make representation of people act 1951. On the basis of RPA 1951 only, this idea of universal adult franchise has given to people, and first election happened in 51 and 52. First elected people came into existence inside parliament. So I can able to conclude the concept of right to vote and right to be a representative is not a constitutional right as per 326. It is a legal right given to people on the basis of the idea of RPA 1951. Already there was a question and there was a controversy happened inside our country, and UPSC gave the final RPA 91. So it is a legal power only, not a constitutional right, not a natural right. Okay. Then, when I'm moving further into the nature of Government of India Act 1935, the most important thing, 75% we got it from here. 75% we got it from here. So what are the things that they, okay, local level, province level, they abolished the provincial autonomy. Okay, and they abolished the diarchy. They abolished the diarchy in province, but introduced provincial autonomy. So province have some kind of autonomy. Dominion status was asked by Indian people for such a long time, so at least they gave provincial autonomy. But the federal form of government is the most important feature came into exist. But the interesting part is that the 1st April 1937, Government of India Act 1935 came into exist. But until 1947, this form of federal form of government not at all implemented by British government. But after independence, from the time of 1950s, the way how the constitutional commencement came into exist, we tried our level best to induct the idea of federal form of government, federalism, federation, to strengthen the center-state relationship. But in practicality, when I commenced the entire Indian constitution from one article to 395, I cannot able to find the word, the definition of federalism anywhere inside the constitution. So again, it is an idea, federal principle, not implemented through Government of India Act 1935, not at all defined by our Indian constitution anywhere. Like last year, around 1920, 20 before that, there was a question related to office of profit, nowhere defined, right only. Granting aid, nowhere defined, right only. Minority, nowhere defined, correct only. Untouchability, abolition of untouchability. But what is untouchability not defined inside? The word cabinet, nowhere mentioned in our Indian constitution except 44th Constitutional Amendment Act. Like this manner, some questions may appear in UPSC. So like federal form of government inducted in 1935 Act, but not implemented till independence. After independence, after commencement of the constitution, it was not defined properly by the constitution, like office of profit, like granting aid and other various ideas. Then we know very well that the federal form of government diarchy was introduced from the area of province to center, like president and people elected prime minister. Okay, and the bicameral legislatures like upper house and lower house also inducted inside the province, and ideas regarding Federal Court of India with the highest appeal before in the name of Privy Council came into existence during the time of Government of India Act, and abolition of Indian Council and the creation of Federal Railways. This is another most important idea came into exist, and appointment of Advocate General, because the concept like Attorney General and Advocate General came into exist in India through the constitutional means. But when I want to discuss about Advocate General, first time came into exist through Government of India Act. But after India's independence, the Advocate General moved into the state level. Attorney General remained as the first law officer at the central level only. This is the way the process regarding Advocate General and Attorney General came into exist. Even I can able to say Cabinet Secretary and Chief Secretary, both initiated as a category of the Governor General's Viceroy's Executive Council and the Personal Secretary, later moved as a Cabinet Secretary at the central level, and the Personal Secretary moved into the category the Chief Secretary of a state. That is a different idea after independence. And other than that, the Act also abolished the methods of the nominated members inside the Central Legislative Assembly. All are elected only, no more nominated. But the most important part, already UPSC asked this question, when they want to go for the ideas of the separation of Burma from India, British India, the UPSC already asked this question. And the most important part I can able to say, for not to allow the spread of national movement via northeastern state to Burma. So Burmese also will ask independence. So they separated Burma from India through 1935 Act from 1st April 1937. But the most important thing is that there are some kind of provision on the basis of Government of India Act 1935. On the eastern side, we separated Burma, but on the western side, a territory from India also separated and annexed with the South Yemen in the name of Aden is part of British India until 1937. But through Government of India Act 1935, they separated this idea of the Aden port into the areas of the concept like Yemen and northern Yemen, southern after independence, they joined together in Yemen. Why I'm saying this? In 2016, the VK Singh, when he was General VK Singh was Minister of State External Affairs, who went and rescued Indian along with the 42 country people in the name of Operation Rahat. So that may be a possibility on the recurrence of the celebration of various, like right now Sudan, few days ago, the way how rescue operation, last year, Ukraine operation, Ganges, like that manner, there may be a possibility. Okay, good. Then Government of India Act 1947, the Independence Act came into exist. Simple way. Okay. But apart from this, when you are looking into this idea, the way how the commencement of the independence came into existence on 15th August 1947 for India and 14th August for 1947 for Pakistan, one day ahead of India, Pakistan got independence. But the most important thing is that when you're looking into this idea of independence, because the 15th August is the most important, significant day for Lord Mountbatten when he was an admiral of Royal Navy on Eastern Fleet at the time of 1945. The Japan surrendered before him on 1945 August 52. So in order to commemorate this particular day and more people need to celebrate, he gave independence to India, some Southeast Asian country, some African countries. 15th August was the reason why they gave independence to India and all. So when we are completing the entire history, like the way the evolution process came into, and after that, the way how the Constitutional Assembly came into existence, an objective resolution also passed by people on the basis of that. Approximately, I told you 2 years, 11 months, and 18 days. These people all together, they joined together, fought and debated and discussed it, and other various things happened. Finally, they enacted the Indian Constitution on 26th November 1949, and the Constitution came into force on 26th January 1950. On the basis of that, India became the Republican country. And while doing so, India don't want to go for Commonwealth citizenship of countries. India is part of Commonwealth group of heads, but not like Commonwealth citizenship. By the way, how Australia and New Zealand and Canada is having the Queen as a titular head and their representative secretary, Governor General as a titular head, and people elected Prime Minister as the real head. In this manner, they are having a method, but in practicality, India went for the people elected, not indirectly. Indirectly, people elected president. Okay, is a titular head for the country. And very recently, also Australia announced on 23 that they are going to remove the pictures of Queen from their currency. That is a very recent development. By the way, how they want to maintain their own neutrality in foreign policy and financial policy by the way of removing the crown as the main pictures inside the currencies of Australia, which happened just a few days ago. Good. And other than that, when you are going further, I am not able to see any question here because since I think some restrictions are here for interacting with the students. So it's a kind of monologue only. I will keep on discuss. You can able to listen. Okay, good, fine. In next class, I will ask them to provide the chat and all. So there may be a possibility we can go for dialogue rather than monologue. So the way how we are going to discuss about the concept is a rapid revision case. Okay, no point of regarding stories. So when I'm going to look into this idea of salient features of the Indian Constitution, The way how UPSC asks, in that format only I am framing this rapid revision class. Most important point. Sometimes, luckily, like previous years, you may get more number of questions. Unluckily, sometimes less number of questions. But definitely, you will get some questions from the class notes. Don't worry. First, it features the longest and lengthiest constitution in this world, along with the principles of written ideologies. And this country is having a sovereign constitution. Okay, in this sense, the Indian constitution is considered as the longest and lengthiest. But when I'm saying a non-sovereign constitution like Alabama state inside USA, that is having approximately 936. I don't know right now how many articles they recently amended. So this is the way the situation inside. So when I'm going to look into this idea of the constitutional provision, the longest and lengthiest, I need to come for a conclusion that why it become longest and lengthiest? Why it need to go for written format? Even though United Kingdom is having an unwritten practice. But why India want to go for written practices in the name of constitution? Because in the area like UK, the constitution was not enacted. Constitution was evolved on the basis of the various norms, values, culture, and Magna Cartas, etc., etc. But in India, the constitution was enacted by the Constitutional Assembly. So its first condition is that it should be go for a format. Evolved in nature, so you can able to make it as an unwritten one. Enacted one, generally enacted principles are come under written form. Second important thing is that when I look into the nature of Independence Day and all after that, the commencement of the constitution time, the literacy rate was single digit for women. Even overall ideas for Indian people also less. So in this nature, illiterate people are more. So I want to write it everything clearly. So there is a kind of mechanism in future when people get independent, people get liberated themselves in terms of literacy, they can able to understand the constitution in more manner. So elaborations are very necessary. First idea, why it become lengthiest. Second important thing is that the geographical vastness. You can able to see the territory from it was considered as a subcontinent. Some people will say subcontinent, including Pakistan, India, some part of Afghanistan, some part of Burma. Over the period of time, some real territory of Pakistan occupied Kashmir and Indian occupied Kashmir and upsides and all greatest geographical vastness. So it became compulsory for me to go into the nature of some more things that I want to fulfill every people's desire. Example, Indo-Tibetan people are there in the name of Mongoloids on northeastern state. Indo-Negroids are existing in Andaman and Nicobar Islands. And Dravidians are there in the southern part, and the Aryans are there on northwestern frontier people area, like that manner, various geographical vastness. So to fulfill them, I need to go. And the historical background, the way how 75% I borrowed it from 1935 and remaining 25% from 1861 Act or UK, USA, and other various countries. So it again become a longest and lengthiest. And another most important thing is the criticism also. The Constitutional Assembly was dominated with the nexus of lawyers and politicians. On the basis of this idea of lawyers come politicians basis, so it becomes compulsory that the lawyer means, doctors means, for example, if the doctor want to write paracetamol, the way how he is writing the paracetamol, except a medical practitioner or a chemist, you cannot able to understand. In the same way, but right now Supreme Court gave the verdict that the doctors need to write their prescription in capital letter that everyone and anyone inside the country can able to understand. But in practical, no one will do that one. The same way, lawyers mean the vocabulary they are going to use de facto, de jure, suo motu, and other various ideas that except lawyers, no one can able to. So it isn't necessary that high skilled languages, the domination of barrister and all, on the basis of that, this is widest things came into. And there is an idea, the way how 395 articles on the basis of various part and various scheduled, a proper elaboration of this idea. Based on that, it become longest and lengthiest. Then when I'm moving into the next level, what are the other various things regarding the constitutional sources? When I want to look into the constitutional sources, first and foremost important thing, 1861 Council of India Act, where the provisions regarding ordinance making or the provisions regarding portfolio, or the provisions regarding budget making, and the prior sanction of president regarding certain bills like ordinary bill and all. Only one ordinary bill, state reorganization bill and the money bill and all. And other than that, the Council of India Act 1935 gave something in the name of Office of Governor, federal schemes, judicial process, emergency provision, basic structure, etc., etc., etc. And from UK, I borrowed the methods of parliamentary form of government, rule of law, single citizenship, cabinet system, writ jurisdiction in the name of prerogatives and bicameralism. These are all the ideas. And from USA, the basic things regarding fundamental rights and judicial review, independent judiciary, impeachment, removal, and other things. Vice president and president is the supreme commander of the military. Like that manner, I have borrowed. And from Irish constitution, you know very well DPSP, nomination of Rajya Sabha MP, methods to of election of president, and all. And from the Canadian perspective, I can able to go that the way how the Canadian perspectives came into exist based on the strong center. Strong center. But even before that, the strong center kind of things came into exist first time through the preamble of the 1918 Act, the decentralized unitary form of government. And residuary power lies with the state as per the recommendation of 1928 Motilal Nehru Committee. But residuary power lies with the center is an idea of Canadian federalism. We borrowed it. And appointment of state governor and advisory jurisdiction of Supreme Court. These are all the other idea, advisory jurisdiction of Supreme Court. We got it from Canada. And from Australian constitution, concurrent list, generally people will say the most important thing, the freedom of interstate trade and commerce. This is another important thing. And the joint sitting of the two houses. And the parliamentary privileges with a limited way. And the most important thing, finance commission. Finance commission is need to be considered by some materials and article sources in online and offline that it is an Indian innovation. That is totally wrong. The way how Ambedkar really specifically talked about this idea of finance commission, even though it is a constitutional body under Article 280 of the Indian Constitution, through the executive orders, every 5 years once, for 5-year tenure or less than 5 years tenure, the President of India will appoint some people into the nature of finance commission. So it is a way how it is going to have a limited, the ways on that we can able to say finance commission is a kind of ad hoc commission only, not a permanent one. The way how the Australian standing finance commission for every 1 year as an ad hoc body, in Indian finance commission for every 5 years and less than. This is the way the finance commission and interstate trade borrowed it from the country like Australia. And from German constitution, we can say able to Weimar constitution of West Germany, the suspension of fundamental rights during emergency, we got it from there. From Soviet Russia, the ideals of justice and fundamental duties. French constitution, we know very well the ideas regarding equality, liberty, fraternity, and some more principles like republic. And South Africa, the amendment procedures and the election of members of the Rajya Sabha. And Japanese constitution, the procedure established by law. So like this manner, we can able to have some kind of idea the way how from various sources we got the various methods. On the basis of this idea only, we are having the why this constitution is a kind of salient feature, the best method from the best country we borrowed from. Then some other features like the blend of rigidity and flexibility, the way how things are going to happen. In some places very rigid, you cannot able to touch. In some places you cannot able to very easily you can go for changing this state reorganization. This is an example for flexibility I can able to say, and rigidity in the sense that even the induction of GST bill as an act through 101st Constitutional Amendment Act is the best example I can able to go for rigidity. Or even some places the approval of not only 50% of the state with a 2/3 majority we have to pass it in state parliament. That is a provision in terms of rigidity. Then we know very well that federal system is a feature. On the basis of that, it may be a federal feature, but India is having unitary bias will be more. The best example, India's first state in 1959 under Kerala government, communist government was dismissed by Nehru government. This is the first thing and foremost important thing we can able to talk about while going for federal system with the unitary bias. But while doing so, the federal system with the unitary bias, I can able to have some more ideas. The way how the federal principles are existing in India, we can able to say it's a federal form of government, but some people will say it is a quasi-federal form of government. It is not completely federal, it's a quasi-federal. And unitary bias will be more. But to manage this federal system, we had a proper methodology in the name of 7th schedule of the Indian Constitution, which properly demarcated the authority between center, state, and concurrent on the basis of union list, state list, and concurrent list. And residuary power will be lies with the central government. The unitary bias will be more. The union government can able to dismiss the state government. Unitary bias will be more. During emergency situations, stateless will be in the hands of parliament. Unitary bias will be more. Like that manner, some more examples in the appropriate places in parliament class, I can able to discuss. And other than that, when I want to look into the idea of federal form of federal system, that at the beginning of India's independence, we had a method of organic federation. Organic federalism is a kind of idea was existing. And this organic, the initial stage, evolutionary nature, slowly and steadily evolved into various characters. On the basis of that, when coalition form of government becomes strong inside India in 96 onwards, by the way, 13-month prime minister, 13-day prime minister, etc., etc., a coalition form of government. On the basis of the coalition form of government, a bargaining federalism is a kind of idea exists inside India, because a political party which had a power inside parliament in the name of numbers, 30 MP, 40 MP, 20 MP, can able to dictate the prime minister for portfolio and other various regional benefit and all, promote the regionalism, is a kind of idea, bargaining federalism. But from moving the category of bargaining federalism into the real federalistic nature of cooperative federalism, the way how government of India at the time of 2017 inducted the concept of abolition of planning commission completely and reducing the concept of expenditure into single category under finance commission and all, is the best example for cooperative federalism. In cooperative federalism after 2017 under the influence of Niti Aayog came into existed, and the reality is that cooperative federalism among the state induces a competition. So there is an idea of competitive federalism in the GST regime also came into existence. So this is the way the federal nature of organic federalism at the time of independence moved into the nature of competitive federalism under the regime of GST. Okay. Then when I'm moving further, parliamentary form of government is a kind of idea we are passed and the basis of the principles of cooperation and coordination with the way of legislatures and judiciary. And here the judiciary is having some upper hand, because India is a synthesis of parliamentary sovereignty on one side and judicial supremacy on another side. This is the way the Indian methods are happening inside our country. In certain places, parliamentary sovereignty, in certain places, judicial supremacy. UK, parliamentary sovereignty ultimate. USA, judicial supremacy is ultimate. And UK, parliamentary sovereignty ultimate. Until 2006, there is no judicial review at all. After 6, with the limitation, we are practicing judicial supremacy as a judicial intervention, but not into the matter of parliamentary laws. Okay, but in India, it is a mixture of parliamentary form and judicial supremacy. Parliament can able to make a 98th Constitutional Amendment Act to make the sense of National Judicial Appointment Commission and 99th Constitutional Amendment Act, and judicial can able to supervise with the help of their authority by the way of nullifying 99th Constitutional Amendment Act, National Judicial Appointment Commission. Is an example I can able to say. And on the basis of that, I can able to say that it is a synthesis of parliament sovereignty and judicial supremacy. Okay, on the basis of that, apart from that, I can able to say in India, it is having an integrated and independent judiciary. Integrated and independent judiciary. Based on these methods of integrated and independent judiciary, we may have a Supreme Court of India since 1950s, 28th of January 1950s. Okay, and the most important thing, it is also having an independent nature from the executive and judiciary, but integrated in the sense of Supreme Court only one body, apex body, and every state or group of states will have high courts, then lower court, like this manner. And other than that, when I'm going to look into this idea of some more salient features, the way how the constitutional provisions are having something regarding the philosophical aspect of fundamental right and DPSP, and some kind of duties after emergency in the name of fundamental duties, some other ideas in the name of universal adult franchise, and all will say that the independent nature of judiciary and independent nature of Indian political system. On the basis of that, these are all the best thing I can able to say about the salient features of our Indian Constitution. But while doing so, on the basis of the above principle, I can able to say that the Constitution of India, which came into force on 26 November 1949 and 26 January 1950, is having a proper objective in the name of taking care of welfare of every individuals and well-being of every individual. Taking care of welfare of all and well-being of every individual is a constitutional objective we are having at present. On the basis of that only, the government is doing so many things. Well-being of all, best example. In 2018, the Prime Minister of India on 15th August 2018 announced Ayushman Bharat. Welfare of all, various schemes and programs initiated by through directive principles and fundamental right and government schemes and program is the best example for objective of the constitution. And when I'm looking into the philosophical perspective of the constitution, I can able to say fundamental right aligned with the principles of DPSP, with the initiative, with the prism of preamble, can able to act like a philosophy of the Indian constitution. Fundamental right aligned with the DPSP on the basis of the values and ethos the preamble want to insert it inside our Indian constitution. Based on that, I can able to say this aspect is considered as a philosophy of the Indian constitution. Okay, these are all the objective I can able to make when I want to discuss into the ideas of the principles of system like uh, silent features of the Indian constitution, silent features of the Indian constitution. But while doing so, some more things now and then, some steering committee, this and that, and all UPSC will ask you just to go through 5 minutes reading of any textbook, proper textbook given by the government of India, so you can able to understand. Normally, so far past 10-15 years, not much question into this area, rare possibilities are there. But after learning this process, when I entered into the constitution on the basis of that article 1 to 396, the first article is clearly saying that India, that is otherwise called as Bharat, as a union of state. There is a specification for everything. India as a Bharat. So, India as a Bharat. So based on that, I can able to call it as a union of India. 1 second. So it's a union. India as a Bharat, as a union of the state, which implies the name of the country and type of the polity described as a union. While doing so, there was a case before the Supreme Court of India a few years before that you should not make India as an India. Everyone should be called India as a Bharat only, because Angresika we have to eliminate that. So Hindi word should be replaced with English. So India should be considered Bharat only. And Supreme Court said it is none of my business. As per the requirement of people, you can either call it India or Bharat. It's up to you. But it is having a provisions of union of state, because there was a debate happened inside India among the founding fathers inside the Constitutional Assembly while going to consider the American methods and other various methods. People argued that the United States of America is an assimilation of 50 states having equality among all irrespective of the population size and all. Assimilation of 50 states can able to secede from the union at any time can able to announce independent nature. So on the basis of this idea only, the concept of the United States of America came into exist, and union have its own federation and the state will maintain their federation on the basis of that union parliament, union executives and state executives, union constitution, state constitution, federal court and the state supreme court, like that manner in United States of America came into. But India don't want to go for the loose connection of the union and the state. India want to go for strong connection between center and state because 540 approximately princely states with the hard work of Mr. Patel united together. So India want to go for any loose connection. Even when Gandhi after independence asked for the idea of village as a Swaraj. This is the most important thing. Village as a republic is the most important thing. By inserting fundamental Panchayat Raj as a most important element. And our founders like Patel and Nehru and Ambedkar totally rejected the idea. After the assassination of Gandhi, just for the sake, Panchayat Raj came as a directive principles of state policy. Because it may create a Swarajya, then later Republic, then Azadi, something like that may happen. Again, it will affect the nature of union. So India decided to go for, instead of United States of India, a Union of India. Here, the states can able to further divide into category of various small, but the center cannot be able to. Indestructible union of destructible state is a kind of idea India want to make into the category of the principles of Union of India. United States. Okay, so Union of the state. Finally, India decided to go for the methods of Union of India. Then while doing so, the way how the territory of India, in India, if you are using the word Article 1 under territory of India, the territory of India means every state and union territory and territory that may be in future acquired by the government of India and Union of India, all will come into force. So when I'm saying Union of India, which means only states, not territory or acquired territory or any other territory. This is the way the Union of India, there the the meaning of territory of India will have wider jurisdiction, wider meaning than Union of India. Union of India means only states. Territory of India means anything in come under the category as a state, UT, territories of acquired things also in future, something like that. And other than that, when I'm moving further, Article 2 and 3, another important thing. Here I can able to say with the help of Article 2 and 3 for your understanding for preliminary as well as mains. I can able to add a territory India which want to take it from outside the country at the time of commencement of the constitution or enactment of the constitution. I can able to say that is an external adjustment Indian founding fathers can able to make under Article 2 after independence, after commencement of the constitution under Article 3. A formation of new state on the basis of the admission of any state from outside the country. External adjustment I can do. But the territory is not part of India until that time. Only the admission happened from outside to including it that in inside and become part of the India. That is an idea of the concept of Article 2. So establishment of new state which is not existing. Okay, or kind of Sikkim kind of things. This is an idea I can able to external adjustment. Hyderabad Nizam, after he fled, it became Andhra Pradesh. There in the matter of formation of states and all. So Article 2 is talking about external adjustment. When same thing in the name of formation of state or changing the nature of the state or modification, annexation and all under the category of Article 3 of the Indian Constitution, here the new states in the name of by separation of territory from any state or by uniting two or more states or uniting two or more part of the states or uniting any territory to any part of any state or uniting part of any state or UT to another state or another union territory, all will come under the category of Article 3. And here, when we are going to do this process of Article 3, under the area of ordinary bill only, you are going to index. The most important thing, when I am going to discuss about the ideas of ordinary bill, So ordinary bill can be introduced inside either house. And another most important thing, ordinary bills will go for constitutional lockdown, deadlock, after the matters regarding deadlock of both the houses. And the ordinary bill can be resolved on the basis of the joint sitting of the houses, headed by the Speaker of the House, something like that. So here in the matter, Article 3, the way how we are going to modify the state name modification and all will come under the category of ordinary bill only, but there is a uniqueness I can able to say this is the only ordinary bill under Article 3 in the name of state formation will come under ordinary bill, but in only cases the prior recommendation of the president is very, very necessary before its introduction under Article 3. The formation of state now under Article 3, the internal adjustment what we are going to do within a country. The president's recommendation is very necessary while inducting this bill inside parliament as a state reorganization bill as an ordinance. So, as an ordinary bill. And apart from this, before going to give his recommendation, president first will ask the consent of the concerned state assembly, and it is not necessary that the concern of the state is going to bind the president or the parliament on the basis of the assembly, the way how it is going to give some recommendation. It is not binding for the president and parliament. Then president will take the final call. So this entire process regarding article 223 will come under the category of external reorganization of states, external adjustment. Article 3 will come under the category of internal adjustment of state. Fine, good. Based on that, the formation of new states will come into force. Modification of those new, changing nature of the states, all will come into. But the constitution has clearly mentioned that whatever the provision I am going to do under Article 2 and 3 should not be considered as constitutional amendment under Article 368 of the Indian Constitution. So this is the most important thing. I'm doing a very, very necessary point by the way of altering the boundaries within and outside the country, by the way of taking territory from outside, modifying within inside, is not at all considered as a constitutional amendment under Article 4 of the Indian Constitution. 4 of the Indian Constitution into the nature of internal adjustment. But the most important thing, students will ask some kind of doubt in classes that Sikkim also inducted with the help of amendment only. Recently, land boundary agreement with the Bangladesh 100th amendment happened. India gave some territory to Bangladesh and Bangladesh got some territory from India. How is it possible if you are saying Article 4 is not considered as an amendment? But for supporting this point, it was in 1960 the Berubari Union case came into existence. On the basis of the guidelines of Supreme Court in Berubari Union case, gave a clear verdict related to this idea that if the government want to give any territory to any other country, or government want to accept any territory from a country, the ratification of the parliament is very, very necessary for modifying or accepting the state outside. The external readjustment under Article 2 of the Indian Constitution can be done only with the help of the ratification of the parliament. So this is the way the process regarding the reorganization kind of things are keep on happening. Okay, under Article 1 to 4, the concept regarding the principles of the ideas regarding reorganization of state or whatever it may be. But sometimes some extra informations are there in lot of guides, but not in textbook. In any textbook, they don't have this kind of information. But questions, majority of the time, as per the standard textbooks like NCRT and NBT only it comes. Even very rarely, some questions are going out of that NCT and NBRT. That is completely based on the recent development with the help of current affairs or year-based classification. For example, last year UPSC asked some question from 1971, the contempt of court, the Bar Council of India, something like that. So it is some completely the platinum jubilee year. Based on that, some kind of question appear, or the concept regarding some kind of act came into existence 50 years ago, 60 years ago, will directly appear in traditional based questions or controversial questions. Like the assassinators of Rajiv Gandhi asked some kind of a bail and prologue kind of things, as the parole and bails kind of things. So during that time, UPSC also asked some question in 2021. Even on the basis of the assassinator of Rajiv Gandhi, they made a new dimension in Indian judiciary, that a confirmation regarding judicial innovation is a kind of idea came into exist after the process of the assassinator of Rajiv Gandhi versus Union of India case. Even though the entire idea started at the time of 2008 by Swami Shraddhananda versus Union of India case only, the concept regarding judicial innovation came into exist. But very practically, I can able to say very recently, assassinator of Rajiv Gandhi versus Union of India case, the bail and parole related controversies came into exist, and UPSC directly asked a question in last preliminary that what is the bail conditions and parole condition and all will come under parole condition, all will come under. So whatever I'm saying, that now the union territories, any acceptance and anything, you under the Berbar Union case, you need to get the permission from the Parliament of India's ratification. So Sikkim, you can able to see the constitutional amendment, not an ordinary bill, not don't consider that, it won't consider as a simple organization bill only, but proper amendment came into exist. And apart from this, some more ideas also, like exception we can able to say that when Indira Gandhi gave the territory to Sri Lanka after 1974 and 76 in the name of Kachativu issue, without the ratification of the parliament, Indira Gandhi gave the territory to Sri Lanka. That was a controversial part. In 2011, regarding this matter, the Chief Minister of Tamil Nadu went to Supreme Court of India, and matter is lying before the Supreme Court of India regarding Kachativu versus Tamil Nadu and Sri Lanka. But the practicality is that if anything you want to get it from Sri Lanka, what you already gave through by executive resolution or agreement, you have to go to the International Court of Arbitration, the Hague, Netherlands, not the Supreme Court of India. At present, Supreme Court doesn't have jurisdiction over these kind of things. So Supreme Court cannot able to give anything, cannot handle this Kachativu issue. Only the International Court of Arbitration, the Hague, Netherlands. This is the only possible solution under these provisions. Okay, fine. Then, when I'm moving to the next level, I already told the way how the concept regarding Article 1 to 4, by the way, the Bharat Union of India under 1, and by the way, the external readjustment regarding state formation on the basis of the ideas of the principles of, I can able to say that external adjustment under Article 2, and Article 3 is internal adjustment, and whatever we are doing under Article 2 and 3 is not at all considered as a constitutional amendment under Article 3 and 4th of the Indian Constitution. But in Beribari Union case, the things are very clear that you have to make amendment if you want to take some territory from outside or secede some territory from India. This is the normal scenario. And other than that, there is a kind of idea people will say that the way how the process, these are all the things already we discussed. Okay, the way how the concept regarding some extra information for preliminary point of view. For example, on the basis of, just a second, sorry. On the basis of 36th Constitution under 1974, Sikkim 75, it was a only associative state of India. Now after become that, it became a full-fledged state of India. So even though under Article 4, it is clearly saying that ratification of the it was not considered as a constitutional amendment act. But why they specifically do under the guidelines of Berbar Union case? So 35th and 36th constitutional amendment came and takes one side. Another important thing, preliminary point of view, when they inducted various states inside India, and Sikkim was annexed with India on the basis of the agreement India signed it with the Chogyal dynasty. The Chogyal dynasty was the one who ruled Sikkim until 48. When they handed over the territory to India through instrument of accession, India, they made a condition that on the basis of that, Sikkim was considered as an associative state from 48 to 74. And that was the only associative state of British India after independence. So after 75, through this amendment, that was 35 and 36, they made Sikkim as a proper state of India and most peace-loving state. Even as per India Act 2001 to 2011, not even single FIR filed inside Sikkim. The Theravada Buddhism is a kind of idea. They are practicing completely inside a Buddhist state like Sikkim is a best example for. Then Article 3 and 4 we did in this area. Here the concept of purpose, the way how the President of India is handling and all will come under this category. Fine. Now the most important thing. When I am going to the next part under this provision, the way how the citizenship, there are some kind of various ideas are existing related to citizenship starting from Article 5 to 8, 9, 10, 11. The two way I have to divide the citizenship, Article 5 to 8 and 9, 10, 11. These are the things on the basis of that idea. Next 12, next class we will discuss about fundamental rights and fundamental duties and DPSP and the preamble of the Indian Constitution. So when I want to look into this idea of citizenship, so the way how politically the people are going to get the citizenship on the basis of that some kind of equality will be given to all. So by birth, a person is getting that equality in the name of natural citizens. By the way, a person moving from one country to another country, joining with that country, living in that country, on the basis of that applying for the citizenship, he will become a registered citizen. On the basis of that, that citizen will become the naturalized citizen. And his sons and daughter in the same country will become the natural citizens. For example, in Sonia Gandhi is considered as a naturalized citizen of India, and Rahul Gandhi is considered as a natural citizen of India. Like the way in America, natural or naturalized citizen, but the condition is that only a natural citizen can be contested in election for American president, along with the conditions of 14 years continuous existence inside America. You are eligible to contest in presidential election of USA. But a naturalized citizen, a person moved into America and settled there and got the citizenship, like Arnold Schwarzenegger from Austria, settled in USA, can be a governor of a state, but not a president of America. But Schwarzenegger's son and daughter can be a president of America. That is a huge difference between comparison of Indian citizenship with foreign American citizenship. In India, it is not clear, natural or naturalized. Anyone can be a president of India. He is a citizen of India. In that manner, only we mention about the conditions of president and all. Okay, good. So these are all the common, right? For a mains point of view, you have to use this kind of idea. Apart from this, when you are going to look into this idea of citizenship, for example, we know very well, until 26th of November 1949, we never and ever had any kind of concept of Indian citizenship. When the enactment of the Constitution came into existence, from that day only, the concept regarding citizenship also came into existence. So when the Constitutional Assembly was adopted inside our Indian Constitution, the way how from Article 5 to 9 is a kind of provision regarding citizenship. Okay, until that the people those are lived inside India is considered as a British India only. Under the crown or the subject to the British subject governed by the British Nationality Act. And who are the people came from any of the princely state had the status of British protected person. So till 26th November 1949, this was a condition. Indian people will be considered in two ways. Some people who become the part of British India under the crown and other various principles of British Nationality Act. Some other people who resided in princely states will come under the status of British protected personality. So this point not at asked by UPSC in any examination. There may be a possibility in the coming examination a question may arise in UPSC. Okay. And apart from this, when I am going to handle Article 5, the simple thing, not much elaborations are necessary in terms of preliminary point of view. We have to just commence the concept. The citizenship at the commencement of the Constitution under Article 5 of the Indian Constitution is saying that the way how every person who was a domicile in the territory of the country was born in the territory, or their parents was born in the territory, or who has been ordinarily resident in the territory of India for not less than 5 years before going to apply for the citizenship, will be into the category of the citizens of India under Article 5 of the Indian Constitution, but the conditions are 5 years minimum before going to apply for the territory citizenship. You should be okay. Not much important, but just to go through this idea. Then second idea, when I'm going to look into the part of Article 6, the right of citizenship of certain person who migrated to India from Pakistan. So this was a condition. On the basis of that, the way how people from the country came into exist. On the basis of that, the partition came 14th August 1947, Pakistan got independence, and 15th August 1947 onwards, India got independence. While doing so, some people who migrated back to India, some people who migrated into Pakistan, and lot of things and confusion came into exist. So, person who have migrated to India from Pakistan, as per under Article 5 of the Indian Constitution, and the territory now deemed to be considered as a citizen of the India at the time of the commencement of the Constitution on the basis of the following provisions. When I'm going to look into this idea, he or either of his parents or his grandparents born in India as defined by the Government of India Act 1935. First condition. Then, when the same person who migrated from the 19 July 1948, at the date before 19th July 1948, after the partition he went to Pakistan, and before 19th July 1948 he returned back to, that is the case, migrated before 19th July, and he has been the ordinary resident of India since the date of his migration. This condition. Or in case the person who migrated on or after 19th July 1948, after 1948, then he registered himself as a citizen of India by the officer appointed for the specific purpose by the Government of India, and application made before the officer in the prescribed manner as mentioned by the Government of India. So these are all the method, and provided that no person shall be so registered unless he has been the resident in the territory of India or at least 6 months immediately just before the date of application he is going to proceed. So I can able to say that when a person who want to be a citizen of India who migrated to India from Pakistan on 19th July 1948, the conditions are there. He or his either of the grandparent or his parents are residents of the India as per the concept defined under Government of India Act 1935, and the migration should be happened just before 19th July. He is eligible to go for the citizenship. But the person who migrated on and after 1948, July 18th, so he need to be come to India and registered himself as a voter, person inside India with the officer appointed by the Government of India for this purpose. And the officer just before the commencement of the Constitution, the way how the manner prescribed by the Government of India and all will come into the force. But while doing so, he should be restricted, the person who is residing in the territory of India, or at least just 6 months before the date of application he put it. In the basis of that area, he is eligible to go into the nature of the citizenship under articles. Okay. Other than that, when you are looking into the areas of Article 7 of the Indian Constitution, these are all not much important. Don't get confused in terms of preliminary, but very, very rarely some question may arise. So what are the conditions I mentioned under Article 5 and 6 of the Indian Constitution? Okay, a person who after his first day of March 1947, 1st March 1947, who migrated from India to Pakistan, and the moment he migrated from India to Pakistan shall not be deemed to be a citizen of India. He went to there and he settled there. But the most important thing is that after the person who migrated to the territory now, which is right now included in Pakistan, has decided that, okay, no, I am not going to reside in there, so I want to return back to India. So he has returned to the territory of India, and on the basis of the permit for resettlement or the permanent return issued by the government of India during the time, on the basis of that, the person can able to apply certain things for Indian citizenship. So this is another most important thing. Based on that, what are the clauses we can able to say? 1st March 1947 is the date. Based on that, 1st March 1947 is a date. On the basis of that, we can able to go into the category. Okay. And other than that, Article 6, the way how it also gave something into the nature of the trade after the 19th July 1940, the way how some provisions, what we discuss in the provision number Article 6. Okay, that also will come under the category. Based on that, the citizenship, we can able to say na some people who migrated into India after 19th July 1948 will also come under the category. Okay, one side. The next one, when I'm looking into the ideas of Article say 8 of the Indian Constitution, I can able to say the provisions which is mentioned under Article 5. The way how the person and his grandparents or the parents all migrated into. Okay, as per the definition of Government of India Act 1935. Okay, on the basis of that, the way how certain people, those who are residing ordinarily, the residents of the country during that time outside India, or the person who shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic and consular representative of India, the place wherever they are existing. Through the application format in the diplomatical presence or consular office, they can able to promote it. Okay, based on that, it is become very necessary that the person who is residing outside the country and the name of Indian origin can able to get the citizenship by the way how they are registering themselves into the nature of the citizenship. But only condition is that as per the Government of India Act 1935, the parents, grandparents, or he himself, something should be there as a citizen of the country. Okay, fine. Good. Another that, when I'm going to look into the Article 8 to 5, 6, 7, 8, all are talking about the way how a person will be eligible into the category of citizens. But when I'm going to look into the ideas of Article 9, a person who voluntarily terminated his relationship with the country and going there and settling there, and sometime he will inform the country that I am cancelling my citizenship, termination of my citizenship. But if he is not, and in any way the information comes to the Ministry of External Affairs, and it is a duty of the government to terminate the relationship of the particular citizenship, so he will become, already he became a part of the other country. So government of India can able to terminate his citizenship. So this is the case. On the basis of that, a person can able to voluntarily acquire the citizenship of foreign country will lose the citizenship under Article 9 of the Indian Constitution. 9 of the Indian Constitution. But under Article 10, the way how the continuation of the right of citizenship will come into force, a person who deemed to be considered as a citizen of India, on the basis of that, the way how he is subject to the provisions of any law that made by the parliament, on the basis of that, continue to be a citizen. So parliament is a kind of authority on the basis of parliamentary laws. In future also, the possibilities are there that the continuation of any citizens can be achieved with the help of the parliamentary law as an outgrowth. And other than that, when I am going to look into this idea of Article 11, the way how parliament is having some authority under Article 11 of the Indian Constitution, based on that, a provision also will make by the parliament related to the acquisition of any territorial citizenship or termination of the citizenship or any other matter relating to the citizenship. It is an exclusive right of parliament alone. So parliament can able to regulate the right to citizenship too with the help of the provision in the name of law. They are going to make it inside a country. So this is another important thing we need to give consider. Okay. Now, when I'm going to look into this idea, the recent development after 2019, the government of India has decided to go to the methods by the way how just before the election of 2019, they had decided to add certain kind of provisions. For example, when they want to look into this idea of citizenship, India faced some kind of difficulties because the way how the problem of citizenship is going to affect the northeastern state in various ways, the northwestern frontiers of Punjab and Jammu and Kashmir. So based on that, there will be always a possibility that the push and pull factors towards India is a prominent one since independence. On the basis of that, lot of illegal immigrants will try to enter into India from Bangladesh or Myanmar or other various countries. Okay, even in Bangladesh case, I can able to see from the time of India's independence to till date, to taking care of the border management, the government of India so far appointed only one committee. From the time of independence to till 2001 and 2, there was no committee appointed by the government of India, no initiatives properly taken by the government of India in favor of border management or illegal migrations and all. So many people from the time of 1971 illegally entered into India from Bangladesh and part of the Indian citizenship, got voter ID, ration card, Aadhaar card, etc., become a citizen of the India properly. So in 2001 only government realized this matter, and first time they appointed a committee in the name of first committee to discuss about the border management issue, Madhav Gadbol Committee. And this Madhav Gadbol Committee in 2002 gave its recommendation to the government of India that at least 3 to 5 lakhs people are illegally entering from Bangladesh to India. Second recommendation, the way how immigrations are happening, migrations are happening in illegal manner, but we are not able to prevent those things. So what is the necessary point? That the way how we are going to handle this concept of immigration, by the way how the government of India is going to make some kind of provision, on the basis of that, the most important initiatives came into exist, that border forces are not enough to handle these things because they need to keep on move from place to place. So there is an important idea of one border, one force came into exist. First, Madhav Gadbol Committee said that illegal immigrants, 3 to 5 lakhs people. Reason is that one border, one force is not happening. So if people can easily know, border forces won't know the exact border, but local people knows the exact, so illegally entering it. And there should be a need for the Department of Border Management to handle the issues regarding citizenship or immigrants. So the committee recommended third important thing. And the most important thing, exactly 10 years ago only accepted by the Cabinet Committee on Economic Affairs in 2013 in the name of Land Border Authority, LPA, Land Port Authority of India. Land, we know only Port Authority of India to taking care of the export import. A Land Port Authority of India is a kind of initiative recommended by the Madhav Gadbol Committee in 2002. All the committee recommendations immediately accepted by Mr. Atal Bihari Vajpayee government, except the Land Port Authority of India. And this idea was in 2013 under Dr. Manmohan Singh, accepted by the government of India, and cabinet committee gave its recommendation and approval for it. And 2014 onward, the Land Port Authority of came into existence. Now it's a 20th year celebration. There may be some possibility in 2023 preliminary. One second. But the second most important thing is that when I want to look into the Pakistan border, so at last in 2018, the second commission appointed by the government of India to taking care of immigration, internal insurgency, or terrorism related ideology or border management in a simple manner, I can able to say that Madhukur Gupta Committee in 2018. Madhukur Gupta Committee in 2018. So Madhav Gadbol Committee in 2002, Madhukur Gupta in 2018, and this committee also recommended that the Pakistan border need to be properly fenced. So based on fencing method, we can able to manage India-Pakistan border. And some more recommendation all, now it is under the consideration of the Parliament and Government of India, so soon they will go. So this is the way, but illegal immigrants is still a problematic thing, and National Population Register and NRC kind of initiatives initiated by the Home Minister after 2019 and all, become a controversial part on one side. On the other side, it want to show the surety that who are the immigrants who illegally entered into India since before 1971 and after 1970. So various initiatives. But there are some kind of other problem came into exist. A definition for illegal immigrants who won't come under the category of this Bangladeshi or Pakistanis, but the people who come under the category of Hindus, Sikh, Parsi, Buddhist, Christian immigrants from Pakistan, Afghanistan, Bangladesh, but not from Myanmar and Sri Lanka, who have lived in India without documentation, can able to get the citizenship on the fast track manner within 6 years. So this is the most important thing. Generally, when I want to look into the process of naturalization, after 12 years of residence with the prior recommendation and proper documentation, only you are eligible to go into the nature of citizenship. But in fast track case, under the constitutional amendment, Citizenship Amendment Act 2019, the government of India decided to go for this method. Based on that, they gave from 12 years, it reduced into 6 years. Only the prosecuted minorities from Pakistan, Bangladesh, and Afghanistan will be eligible to get this idea, and those should be belong to the category of Hindus, Sikh, Parsi, Buddhist, Christian immigrants. All will come under the category of prosecuted minorities. So based on this particular initiative, the way how some kind of methods, the legislation also applied to the category of the forced and compelled to seek shelter in India. That is why the prosecuted minorities kind of things are there. And the cutoff date you can able to apply for on 31st December 2014. On the basis of that, the way how people entered into the India before the date, on or before the date, can eligible to apply for this ID. Okay, so based on that, what things are happening inside. At present, I already told you that the resident who is residing minimum 11 years inside our country only eligible to go for this kind of idea, and after 12th year they can able to go for proposal of the citizenship one side. But this act also made some kind of proposal to amendment certain provisions in the name of section D of 7, providing the possibility of cancellation of overseas citizen of India registration where the OCA card holders has violated any provisions of the Citizenship Act or any other law in force. Based on that, so there may be a possibility that apart from the minimum 11 years condition through amendment, a person who did something against the act of Overseas Citizenship Act will be also government can also able to cancel their citizenship. But the most important thing when you are going to look into this idea of the prosecuted minorities, there is a restrictions that the prosecuted minority settlement, this concept won't apply to the areas under the 6th schedule of the Indian Constitution, where we will say that 80 state, except areas like Manipur. M means Manipur, other state, Meghalaya, Mizoram, Tripura, and Assam. Assam, Tripura, Meghalaya, Mizoram, but not Manipur. Okay, 80 states are considered as the 6th scheduled states. So these 6th scheduled state category, your constitutional amendment bill and its settlement won't happen. And second thing, the act will also, the amendment once it come into force, it won't applicable towards the states where the inner line permit letters are happening in the name of Arunachal Pradesh, Nagaland, and Mizoram. There, the eligibility related to this idea also won't be applicable. And other than that, when I'm going to look into this idea, the National Register of Citizens, NRC, the way places like Assam, there the target regarding illegal immigrants and all. So the person have to prove either their ancestor who are part of the Assam before and March, the day how the liberation of Bangladesh came into one, either on or before March 24th, 1971, you must be moved from Bangladesh to India, then you are eligible to be a part of Indian citizenship. Or after 25th March onwards, if you illegally enter, means you are illegal migrant only, you need to go back. But when I'm going to look into this idea of National Register of Citizens, the government decided through amendment will be expanded to the whole country, but not on the basis of religion. Only in CAB, the constitutional amendment bill, only the religion is a kind of things will come under. But checking the national registration in terms of citizenship before on or before 24th March 1917 is a criteria. Based on that, the government of India want to check everybody who migrated from Bangladesh before, after the date, settled properly in Kerala, Tamil Nadu, Karnataka, everywhere and everywhere will come under the category of this kind of things. So this is another important provision in the recent past the government of India made. But apart from this, I already told the way how the entire process regarding the citizenship is come under the nature of dual. I already told dual citizenship we won't accept. But the matter is regarding dual citizenship. When you are going to look into this idea of dual citizenship, on 6th February 2020, the government in parliament made that India is not ready to go for dual citizenship here afterward. So no doubt in that one. The dual citizenship we are not going to accept. Okay, which usually come under the Citizenship Act 1955. But there is an idea, the Overseas Citizen of India OCI card, India gave to people, and these overseas citizens not as citizens because they left India, they does not have the option of dual nationality in India. They settled in some other countries 100 years, 200 years before. They are not part of the Indian citizenship, but their origin is India. So based on that, dual citizenship they planned. For that, I need to go back to the ideas of the same 2002. By the way, how Mr. Atal Bihari Vajpayee government appointed a committee, not only in the name of Madhav Godbole committee, but there is another important provision. In our politics classes, we are going to discuss Mr. L.M. Singhvi. Even in our foundational class, we already discussed that L.M. Singhvi in the terms of first on the basis of Panchayat Raj institution, his recommendation in 1986. Second time, we will discuss L.M. Singhvi on the basis of Lokpal. In 1962, he defined the term, coined the term Lokpal. Sir L.M. Singhvi, who first gave some recommendation in 1986 in terms of Panchayat Raj. Even before 1962, he was the first person in our country who defined what is Lokpal, coined what is Lokpal. Okay. At last, in 2019 March, the government appointed India's first Lokpal just before 2019 election. But the same L.M. Singhvi also appointed by the government of India under Mr. Atal Bihari Vajpayee in 2002 to discuss about the matters regarding non-residential Indians or overseas citizens of the country. On the basis of that, the L.M. Singhvi committee, otherwise called as Diaspora Committee, accepted that some kind of provision we need to modify in the Citizenship Act 1955 and Representation of People Act 1951. On the basis of that, only the first time the committee recommended for dual citizenship. Dual citizenship. Okay, so based on that, the government of India asked the L.M. Singhvi committee to proceed further. Based on that, in 2002, this L.M. Singhvi committee gave some kind of recommendation to the government of India that 9th January 2003, every year here afterward, we need to celebrate the day as NRI Day or OIC Day or Pravesi Bharatiya Divas Day, PIB, Pravesi Bharatiya Divas Day, PBDD or NRI Day or OIC Day. And second most important recommendation made by the Singhvi committee, because 9th January onwards we have to celebrate since 2003. And now 20th year celebration, there may be a possibility in preliminary UPSC may ask some question regarding this or citizenship regarding this. And second important thing is why they have selected 9th January? Because long back, it was in 1915 in the name of Mohandas Karamchand Gandhi or Mahatma or Coolie barrister who came from South Africa to India on the specific day as a very popular non-residential Indian who returned back to India. So So they fixed 9th January as a day for NRI Day, PIO Day, or OIC Day, or Pravasi Bharatiya Divas Day. And second recommendation the committee gave to Indian government that there should be a separate department in the name of overseas, a diaspora department. And within 1 year, the government lost its significance. A new government came in 2014, so 2004, Congress government, and they saw this idea was really good. So what they did, instead of department, the government started saying that we have to go for separate ministry for overseas, and Mr. Vayala Ravi was appointed by the government of India as the first minister for overseas since 2004 onwards, 5 onwards. And 2003 onwards, January 9th, we started celebrating Pravasi Bharatiya Divas Day, NRA Day and OA Day. So in order to support this mechanism only, first time they made some kind of provision inside the Citizenship Act 1955. Based on that, a person, overseas citizens of India status amounts to the partial citizenship. It removes all the barriers in terms of entry, exist, living, working in India, but does not allow the right to vote. You don't have the right to vote. You come, go, live, work in India as a OCA, but not have the right. But in 2019, the Election Commission of India, as part of this idea, received some kind of recommendation for the implementation of electoral reforms. On the basis of that, the voting right will be given to non-residential Indian. Generally, they must come to India for voting. It is impossible for them not to come to India for only voting. It is huge expenditure. They are blue-collar workers, majority of the people, poor people, middle-class people. How only for voting they will come to India? So better, what necessary, either they ask a ballot system like USA, every embassy they will keep a ballot and American citizens go and cast their vote, or else the postal vote they recommended. And right now, the government accepted the provisions on the basis of the electoral reforms by the Law Commission of India. The postal wallet is a possibility for NRI residents, but not yet implemented by the government of India. Only in recommendation nature only it is existing. And second thing is that as a part of this LM Singhvi committee, a person who registered himself as an overseas citizen of India eligible to apply to Ministry of Citizenship under Section 1G of the Act 1954. So if he is registered as an OCA for 5 years at a stretch and residing in India 1 year just out of the 5 years before going to make the application, and that person who ready to renounce his citizenship in foreign country can eligible to get the citizenship of the country, Indian citizenship, he can able to get it back. So this is the most important thing we need to keep it in our mind. The way how diaspora committee, otherwise called as Pravasi Bharatiya Divas Committee, at the time of 2002 recommended for 9th January 2003 onwards, we have to celebrate this NRI PAO Day. Till today, every 9th January, first week of January, second week of January, we can able to see overseas citizens. Okay, and the overseas OCI and people of Indian origin is a kind of idea also accepted those things. And finally, on 6th of February 2020, the government very clearly mentioned that before the parliament, the dual citizenship is not we are going to permit it under the Citizenship Act 1955. It may create a lot of problem inside our country. So India, instead of that, the overseas citizens card we are offering. Based on that, the person who got the overseas citizens card is not an Indian citizen, but he can able to have some kind of opinion by the way traveling in India, living in India, working in India without having the concept of voting right. It's a kind of eligibility. By the way, how 51G of the Citizenship Act 1955 was modified by the Ministry of India, Citizenship under the Council of India Act. On the basis of that, you can able to register yourself as a OCA for 5 years at a stretch, and before going to make that citizenship into India, just 1 year before making that application, if you reside in India and you're eligible to renounce the foreign citizenship, then you are eligible to come to the category of the citizen of the country. Okay, you can able to get it back the citizenship. So these are all some kind of ideas, the way how the constitution in the recent past modified those kind of provision. On the basis of that, the initiation regarding all kind of provisions regarding citizenship and all came into exist. Okay. But we're looking into this idea, for example, when I want to look into the concept of the citizenship, still it is a controversial part, the way how we discuss about the matters of citizenship on the basis of the principles of duality. Since India doesn't permit the category of duality of citizenship, India is strictly going on to the nature of single citizenship only to the Indian people. But there are some kind of provision given by the government of India in the name of visa on arrival scheme. Visa on arrival scheme. So based on that, the people of Indian origin will get some kind of benefit with some countries. Initially 16 countries, and later part it extended to various other countries. Based on that, a priority will be given to the Indian origin people or Indian citizen and all. Here, the diaspora kind of things came into existence in 2003 onwards, which really classified the nature of NRI and PIO or overseas citizens through this Act of Citizenship Act 1955 in various ways. The first and foremost important condition, a person who is residing inside our country, a citizen of India, for the employment opportunity, if he stays outside our country beyond 180 days and more than that, will consider as a non-residential Indian, NRI, for an economic purpose, employment opportunity purpose. And the person who renounced the citizenship of India and migrated to other country and settled there before 100, 200, long back, before the commencement and after the commencement and long back, will consider as the people of Indian origin or overseas citizen of India. And now it became a controversial part that only one person, same person, we are saying OCA and PAO. Now government of India decided to merge everything in together. Now overseas citizen of India only is legal term, not people of Indian origin. So OCA card only we are using, not for the purpose of citizenship, but for entry, exist, living, working, and those areas only we can able to accept the concept of right to vote. Right to vote. But there are other kind of provision also to strengthening the relationship with various countries. Diaspora is the most important idea, because when I'm looking into the concept of diaspora, I can able to say the Indian seed which originated in the place of Indian territory later germinated into various places and started residing there as a citizen of those countries will come under the category of overseas Indian citizens, a non-residential Indian citizen. And we want to get the knowledge back to India, because this idea was totally on the basis of Dr. APJ Abdul Kalam and Dr. Mr. Atal Bihari Vajpayee, the way they want to bring the knowledge back to the Indian society, because such a long time on the basis of the writings of Dadabhai Nauroji and R.C. Dutt, where at the time of making of the Indian constitution or at the time of the revolutionary movement or the freedom struggle movement, we can able to come for the conclusion these people really helped the people to into the various category by the way how R.C. Dutt, by the way how Bas Dadabhai Nauroji, the grand old man of India, first initiated the process regarding the draining of Indian wealth, was supported by the popular economists in the name of R.C. Dutt on the basis of his writing and economic principles. But after India's independence, we tried our level best to do something, but the knowledge of liberalization, privatization, globalization induced a concept into various ways. Based on that, from the category of business process outsourcing, BPO kind of things came into exist, which started sucking the blood of Indian employees, and that also moved into other category of from business process outsourcing, moved into the category of knowledge process outsourcing, KPOs. So in this situation, in order to bring the mind that Indian IITians and AIMS doctor, all the people who got the employment opportunity, the educational opportunity through IIT and IIM and all, moved back to various countries and settling there is a kind of idea. So initiation of diaspora community under LMC became into exist. On the basis of that idea only, the people decided to go for the celebration of diaspora community in any way. Those people of non-residential Indian will come back to India as a citizen to see their family. But the people of overseas citizen of India who terminated the relationship with India and settled in foreign countries, in what way we are going to get the benefit from them? Diaspora, affinity towards India, bring them back to India as a Prime Minister of Singapore, President of Singapore, member, the Defense Minister of Canada, or the Prime Minister of UK, and they may have some kind of affinity towards India. Based on that, bringing an Indian seat back to India in the name of overseas citizens or in the name of people of Indian origin may benefit India at the international level in various ways. For that only the diaspora community, by the way of amending the Citizenship Act 1955, came into exist, and which only discuss about the principles of the 51G of 1955 Act. And there is other provision regarding the Representation of People Act. On the basis of that, in future, the government may give some kind of ideas in the name of voting right to non-residential Indian through a postal ballot system is permissible in India. Like the way the discussion is going on, Law Commission also made a recommendation regarding these things. There may be some possibility. Okay, so these are all the overall idea a student can able to make when they want to look into this process of polity rapid revision class in the nature of making of Indian Constitution, the salient features of the Indian Constitution, India and its union and its territory under Article 1 to 4, and from the area of 5 to 11, by the way of we are going to look into the matter of citizenship. And apart from this, the way how the diaspora kind of things are going to induce the idea of Indianization process with the help of some kind of affiliation that diaspora communities are going to bring. Because best example I want to make it. In 2012, UPSC asked this question. When the concept regarding Lugist policy came into existence in 1992, on the 20th year celebration, the way how UPSC asked the Lugist policy and cornerstone of Lugist policy, economy and culture. In the same year, UPSC asked another question regarding diaspora community. Because diaspora initiation came into existence in 2002 and 2012, there was a question in preliminary and mains also, the difference between NRI and OIC citizenship. NRI means a person who is residing outside the country more than 180 days, is a non-residential Indian, is considered as a new diaspora community. A person who left the country and settled in other country by the way of terminating his relationship long back before the centuries and centuries will come under people of Indian origin or overseas Indian citizens, and these people will come under old diaspora. That was a question in 2012 mains on the 10th year celebration of diaspora community. UPSC already asked. There may be some possibility in 2023 by the way how some kind of other initiation regarding diaspora community like 2019 provision due to COVID and all, no much question here. So repetition of 5th year celebration of diaspora community or recent development in terms of electoral reforms under Representation of People Act 1951 regarding both postal ballot system or regarding diaspora community in the name of merging OIC and PO together, or other various possibility in the name of Citizenship Act 1955 under 51G of the section. By the way how concept regarding amendment regarding monetization of the process of overseas citizens eligibility to reappear those people into the category of citizenship from foreign countries, also a possibility we have to discuss here. So in this manner, I have summarized the entire process regarding. Some point I may missed it. From my point of view, for the 23, it may be not important. Like that manner, I may miss some points, so not much things. But in coming classes, for the next class, when I'm going to handle, I will discuss about preamble, fundamental right, directive principles of state policy, and fundamental duty. What are the possibility in preliminary examination? We can able to expect some kind of questions and all the things I will discuss in those areas. Okay, I will discuss in those areas. Other than that, I usually tell to my students who are the people are going to get ready for 2023 preliminary examination right now. Almost it is the end of April and beginning of January month. So when you are going for revision only, just keep certain things in your mind that what happened in 2019 18, what happened in exactly 2022 and 23 24, 5 10 15 years ago what happened, 20 years ago what happened. Make chart for this. At least in this year based classification, like previous year 2022, 27 question appeared from this year based classification. And 2018 was the toughest question as per the newspaper, and they mentioned about it. And from that A series, first 40 question and 24 question came from year-based classification. In my old videos, everything is there, how to do the year-based classification. If time permits, we'll going for revision, give more important to those kind of year-based classification, will really help student to do well in their examination. Okay, so no doubt in that one. By the way of the rapid revision, what we are going to do, 6 classes has been permitted for me. So first class got over. Within remaining 5 classes, I will do the revision of the entire polity for 2023 preliminary examination. Based on that, easily you can go and get some kind of opportunity at the time of your examination. Okay,